Thank you very much, everyone, for being here this evening. I'd like to echo Sally's acknowledgement of Ngunnawal and Ngambri country and extend my own and the panel's respects to elders past and present, and what a privilege just now to be able to hear that in language too, so thank you. The notion of national security is a contested one. There are views that national security is not capable of any definitive legal definition and must change according to context, time, and history. Whether or not this is true, the reality is that notions of national security are no longer politically bound to the conventional conceptual limits of militaristic threats, espionage, spies, and honeypots. Well, of course, these all remain. Instead, issues of national security are widely accepted as including challenges such as social cohesion, disinformation, food security, climate and natural disasters, and to the unique logistical challenges posed by human activities in cyberspace and outer space. In short, the events of the 21st century have shown that human security and national security are not entirely discrete fields in any practical sense, despite academic objections to the conflation of the two. This is not to diminish in any way the very real risks posed by current geopolitical contexts. The Russian war in Ukraine, the bloody conflict in the Middle East, as well as tensions closer to home. It is more to say that traditional and non-traditional national security risks are now inextricably interconnected. As observed by just last week by the ASIO Director General in the annual threat assessment, the most confronting thing about the new security environment is there is no single security concern. He also went on to note that the impacts of social media, mental health, the spread of misinformation and conspiracy theories, encryption, growing grievance, and the radicalisation of minors all require whole of government, whole of community, whole of society responses. He also made mention of the issue of social cohesion in the face of increased instances of hate crimes, describing a polarised, grievance-rich environment in which social cohesion will remain strained and we can expect spikes in communal violence. This threatens both the safety of individuals and the stability of our entire society. They must stop. When we are divided, we are more vulnerable to external threats, including foreign interference. Our first responders are diverted, and those who seek to divide us have the gate left open for them. Our cooperation, kindness, and social solidarity with one another is a type of defensive armour, and we cannot afford to let it go. The law has a role to play in this, as we have seen in the recent passing by the government of additional criminal offences relating to hate crimes. But this is a whole of society problem first and foremost. Law is simply a tool. On another front, successive defence strategic reviews have now been unequivocal in identifying climate change as a national security issue, noting not only the impacts on human security, but that the acceleration of major climate events risks overwhelming the government's capacity to respond effectively and detracts from defence's primary objective of defending Australia. Social and economic inequality has also been identified as a threat to national security because it disrupts national unity, quality of life, and wealth distribution. Addressing non-traditional security risks are just as important in safeguarding the people as ensuring protection from soldiers of the enemy. Others have also noted the link between economic inequality and far-right populism in a way that frames social justice and legal justice as a national security issue. Of course, there are clearly risks in making everything a national security issue. Securitization can curb liberties, lessen imaginations of more creative solutions, and take away from the very important core work undertaken by defence and intelligence agencies. At its bare minimum, however, perhaps we can agree that national security is the nation-state's right. It is its obligation to keep its existence, citizens, and values safe. It is a type of guardianship. The role of law, then, is to enable, operationalise, regulate, and sometimes to restrain the arms of that guardianship. In turn, this means that law is inescapably and inherently interdisciplinary, constituted by disciplines such as the criminal law, the Constitution, questions of administrative justice, immigration, military law, and telecommunications law. And of course, inevitable intersections with human rights law as we negotiate tensions between freedom and security. National security also intersects with principles of international law. And you're starting to get why I do all the things, right? Not necessarily well, but all the things. As we balance our need for intelligence with the sovereignty of other nation states and recognise, of course, the impact of global security on national security and the expanded lawmaking authority that membership of an international treaty can actually grant the Australian Commonwealth, as well as our obligations to both individuals here and in other states. Recently, at a conference I was at, I heard a senior military officer say that international legal order is less about rules governing relationships, but about relationships governed by rules that enhance development and enhance peace. So as you might imagine, having said all that, when I went looking for a text with which to teach national security law to our highly multidisciplinary body in the NSC's Masters of National Security Policy, I couldn't find the book. I couldn't find anything that engaged in these issues in a broad way that wasn't in a particular silo, understandably compromising breadth for depth. But a bird's eye view is still incredibly helpful and can help manage the risk of not being able to see the forest for the trees. So as they say, if you want something done, do it yourself. So I approached the Federation Press, thank you Tricia and Jason, with the proposal, and they kindly accepted. I'm grateful to Trish and Jason for trusting me with the project. I'm also very grateful to Professor Rory Medcalf and other colleagues at the National Security College for taking a gamble on including a lawyer in your interdisciplinary team and being so supportive of this project. Thanks are also owed, in particular, to Olivia, Brooke, Tim for their support of this event and for the academic program in general. A particular shout out to Tanuj, who very patiently responded to my after-hours queries around colour schemes. Is the pink on the cover too pink? I'd also like to acknowledge my academic colleague, Kevin Robb, who I think is also in the audience for his collegiality along the way as well. If you'll forgive me now a momentary diversion, just briefly, you'll see on Roman number, page 10 of the book, that it is dedicated to Jack. Jack was my younger brother. He died right in the middle of this project from injuries sustained while in NDIS care, and technically speaking, incurred in the course of a Queensland police operation. This is not because he had done anything wrong, but because in Queensland, police are used for mental health call-outs, and Jack lived with autism, schizophrenia, and PTSD. There are still 3 or 4 inquiries outstanding in relation to his death. However, the Queensland Health report that my family did receive acknowledged that inadequate information sharing between Queensland and New South Wales was a contributing factor in Jack being let down by systems that were supposed to help him. It also speaks to the role of mental health management in a federation, something we have actually seen play out in security events. It is a reminder that invariably the nuts, bolts and glue of organisational effectiveness invariably depends on the kind of mundane simplicities which are too often neglected in the supercharged atmosphere of high-end deliberations. The small things matter. Ironically, one of the chapters I wrote in the book with my colleague James Mortensen is on the challenges a federal system and information sharing between states poses when responding to national security threats. Decentralised power can be a wonderful thing, but sometimes our federal system allows for buck passing and disjointed responses to national security risks, as we have seen in the management of climate change, the environment, and as we saw, for better or worse, depends who you ask, during the COVID-19 pandemic. In my view, the constitutional mechanisms for a more cooperative federalism are poorly understood and generally underutilised. We are doing better, but we can do better still. It will save lives. How I managed to land the project in the aftermath of that while also teaching full-time, I'll admit I don't actually know. But I do know that I have brilliant authors who are reliable and professional, and that was a significant factor. So thanks are also owed to each of the 21 contributing authors. Imagine herding those cats, just to say. Thank you, Dom. Including some in the audience tonight, who I'll introduce in a moment. But also to acknowledge I was assisted ably by research assistants Alana Bonifant, Jacob Huth and Andreas Berg. I'm also pleased to say that of the 22 authors, including me, 10 were men, 11 if you include Professor Rory Medcalf's foreword, and 12 were women. So almost 50-50 gender parity. More law is not always the answer. In fact, the general law of more law is the law of unintended consequences, overreach and cramming ourselves into legislative corners we can't back out of. Intelligence practices often require the balancing of liberty and security, with the protection of human rights sitting on both sides of that equation. Security is not an abstract value, it is also the security of our rights and our values. In Sophie Deroy's wonderful book on intelligence and international law, she observes that national security is the means to the people's security and not an end in itself. The balancing act required here requires flexibility and moral reasoning, and this is the role that law and lawyers can fill. Law also faces the challenge of keeping pace with technology, like Sisyphus and his rock. Moreover, it demands a granular understanding of how these rights can be exercised and balanced in practice in the context of a country and a globe which is changing at an exponential, supercharged rate. National security law is certainly more than the sum of its parts, and I look forward to touching on some of the key issues in a discussion with a sample of the book's authors this evening. Tonight on stage, in just a moment, we will have Rebecca Ananian-Welsh, Douglas Guilfoyle, Sangeeta Pillai, and Dominique Dalla-Pozza. Their bios are available online, but I can assure you they're all fabulous. Respectively, they are experts in the independence of the courts, international law, and foreign interference and espionage. We also have Lauren Sanders in the audience, another contributing author who wrote on the intersection between the laws of armed conflict and national security. Fair warning, any questions on call-out powers, I'm probably going to flick them to her. You'll see from the chapter list that other areas covered in the book include executive power, human rights, gender, counter-terrorism, cyberspace, biosecurity, use of weapons, maritime law, and space law. James Renwick KC, in his very kind review of the book for the Australian Law Review, has suggestions for what we might include in a future edition. So watch out, Federation Press, here we come. I also think in retrospect, the book should have had a standalone chapter on climate, social cohesion, and intelligence. There's also a dire need for a cases and commentaries book if anyone wants to take up that mantle or pay me full time to do it. For now, though, we will move to a discussion on examples of issues raised by the book. We will have around 10 minutes for Q&A at the end of that, and then move to some words from the current independent national security legislation monitor, Jake Blight. Before we do that, I do just want to take one moment to acknowledge those defence, security and intelligence professionals who work quietly to keep us safe and for whom there will be no book launches, no names in print. Thank you for the work that you do. The critique we as lawyers make a necessary component in ensuring we do not become what we seek to defeat, but that makes us no less grateful. Thank you, and please join me in welcoming our panellists. So, Beck, if you'll allow me the informality. Rebecca Ananian-Welsh is an associate professor at the University of Queensland, and as I mentioned, her expertise is on the independence of courts and why that's important. At first instance, Beck, this sounds like a bit of a dry and a technical topic, but it becomes really important in balancing the relationship between the individual and the state. In your view, what are some of the key issues in this area and why do they matter?
Dry and technical. I've come all the way from Brisbane. No.
Best area of law ever.
Yeah, best area of law ever. Thanks, Danielle, and thanks for inviting me to be here. Look, I'm going to try and say really what you said at the beginning about why this is important, which is, in your words, that we don't become what we seek to defeat. The challenge in all of this is, of course, to protect national security, because that's the success of the nation, the existence of the nation, and in doing so, not to sacrifice the things that make the nation worth protecting. And one of those things, the one I'm fascinated by, is the justice system. But there's so much more going on there when you think separation of powers. So when I, as a constitutional lawyer, think about how do we protect national security, I think about power and where it is and where it isn't and why. And it's got more gravity, I think, coming to Canberra and saying that, because there's people in this room who wield real public power and who I hope and I'm sure are very keenly aware of the boundaries of that power, of what duties they have, of what duties you don't have, of what it would mean to overstep those boundaries. When we think about who has the power in a kind of three branches, separation of powers sense, executive, parliament, courts, who is protecting national security? We think the executive government. police, military, etc. Parliament has a really key role to play, of course, but a lot of what they're doing in creating law is giving powers and setting boundaries of power for the executive. What on earth do the courts have to do? Courts are uniquely unexpert and kind of inappropriate in some ways in the national security realm. They don't know the things that many of you in this room would know. Judges aren't out there, they're not getting briefs, they don't have security clearances. But yet the courts play a really critical role in the national security world and in the legal world, of course. And that is around policing the boundaries of those powers, in simply interpreting and applying the law. So in my chapter, I look at kind of 3 ways the rubber hits the roads when it gets to the role of courts in national security. One is defining national security, and the other 2 are secret evidence, so having national security information in court and that tension between secrecy and openness. And the last one is preventive justice. Can courts play a role in stopping bad things from happening rather than just waiting till they happen and reacting? I'm not going to talk about all of them because you all have to read the book. But a theme, it's for a sale out there. Trisha's got plenty of copies. A theme, the place that I get to here is that national security, is that courts shape national security a little, but national security has played a big role in reshaping the courts over the last 25 years. So the first thing I look at is defining national security. And there's a really well-accepted kind of, you could say doctrine, but just it's well-accepted that that's not the place for the courts to really be. But some countries don't have legal definitions of national security, which mean the courts just accept what the executive says. We do. So it's written down in law that this is national security, which naturally means that something else isn't. So the courts will have to resolve questions around whether such and such fits into the definition of national security. They do so in a deferential way, really aware of what they don't know and where the appropriate bounds are. But that hasn't stopped them from issuing warnings from time to time, which was done. I'm a lawyer, I've got to cite cases, but the case of Thomas and Mowbray in Gummow and Crennan's judgment, they say maybe the Parliament has overstepped the bounds here and defined national security too broadly. Maybe you should think about this differently, but yet we're going to apply it. So that's one way that courts might shape national security. The other way is far more pronounced. And so there's a lot about the security world that doesn't fit nicely with fundamental tenets of the justice system, like open justice. We can't have every security brief, the way every bit of information was found, every operative kind of cross-examined on how they got the information, et cetera, happening in open court. It just can't happen. And yet we do need to hold intelligence operatives to account sometimes. We need to have those court cases. So what we've developed in Australia is a system of secret evidence. I think it's highly complicated, and I'm not going to bother, read the book. But what's interesting is that something that has been justified in this niche, extreme context of national security and the way like intelligence operations, etc., has now been copied over into the regular criminal law of pretty much every state and territory of Australia, except the ACT, interestingly enough. So there's now secret evidence schemes across Australia and to deal with things that are definitely not national security. The other one that I look at is preventive justice. Of course we want the law to act before something like 9/11 happens. We need to stop that from happening. We can't just wait and react afterwards. But that idea that you can constrain people's liberty based on what they might do in the future rather than what courts have been doing for centuries, which is so this person broke the law and now they have to suffer consequences for that past thing, that was created or really strongly developed here in the national security sector. It kind of took off, and now you'll find it increasingly in the regular criminal justice systems of the states and territories and growing all the time. So what I get out of this is separation of powers is important and not at all dry and technical. But when no, that's right. When things are happening in the national security sector, even if they're justified there, we do need to have the kind of caution and awareness and reflection that is demonstrated by kind of this multifaceted approach in the book to make sure that it doesn't roll out everywhere, or to kind of build those boundaries around it and think about when it is and isn't appropriate.
That's a really pithy summary of a really technical issue. Thank you. The issues around transparency and, of course, preventative justice are an ongoing theme. And we've seen that increase in recent time in litigation about the court stepping in and deciding what's punishment, what's not. Can the executive do it? Can courts do it? So if we have time, we might loop back to that, or we can chat about it in Q&A as well. Moving on to Douglas, who is from the University of New South Wales, Canberra. So maritime security, in the news a bit lately. Anyone notice? I appreciate you're a lawyer first and foremost, but as someone who also works in an interdisciplinary environment, as you do, what do you see as the key risks in maritime security, and what are the key legal challenges from your perspective?
Right. Thank you, Danielle, and I'm glad you didn't introduce maritime security as a dry subject.
I like dry things. Dry things?
You can't really talk about maritime security or the law of the sea without puns creeping in everywhere. It's some sort of quirk of the English language. So if I lapse into boating metaphors, you'll know what's going on. But before I come to some of the key challenges, just a few things. First, I'd like to acknowledge my co-author, who couldn't be with us this evening, Keelan Anderson, who is terrific to work with. And just in terms of why we should be concerned about maritime security, where I normally start with students is, look at a map, right? I mean, we're an island continent,
by sea.
and we connect with the world through the ocean. No matter how much we think we live in a digital borderless age, the way we interface with the rest of the world is a maritime affair. Maritime security is unfortunately complex, both in terms of definition and legal structures. We reduce it to crystalline clarity in the book, which you should buy. But in terms of definition, sometimes it becomes all-encompassing, right? Fisheries, environmental security is therefore part of maritime security. Transnational organised crime, be it the illegal arrival of people or drugs, you have a sort of criminal law element. Oh, but wait, rising powers and global competition, the Navy has to be in there. You have hard security as well. Submarines. So one of the difficulties is sort of putting four corners around the concept of maritime security and working out what you do and don't want to discuss. But then also, as I've said, Australia is a country that interfaces with the world through the ocean. One of the areas where we very faithfully and directly implement international law is the UN Convention on the Law of the Sea and how it interacts with our domestic legislation in terms of our defined maritime zones. But then you've already adverted to the complexities of federalism. There's the little known and quite complex constitutional settlement about how the Federation manages our maritime affairs as between state and Commonwealth responsibilities. So there are layers of legislation there that interact with the international realm. But in terms of issues of prominence, the sort of four we flag in the book, which was obviously written before events in the last week in the media, were unauthorised maritime arrivals, illegal, unreported and unregulated fishing, submarine cables, and the stability of maritime boundaries in the face of climate change. Now, I'll sort of focus my remarks most on the last two, but I'm happy to take any others in questions. When I said that, how we connect to the world, even in a digital age, is a fundamentally maritime affair, one of the things I meant was cables. And we've seen in the recent conflict in Ukraine, Russian activities in terms of severing cables connecting European countries. In the event of a major conflict in the Indo-Pacific, there's about a dozen odd cables that connect us to the rest of the world, and there are a number of choke points for those cables, particularly in the global cable system, say in Hawaii and the Suez Canal. There are a number of places where you could severely disrupt world connectivity with a limited number of military operations. And the law we've got protecting submarine cables essentially dates from the 19th century in times of peace and hasn't been greatly updated in the UN Convention on the Law of the Sea. And in terms of the laws of war, hasn't really been significantly updated since the Second World War. And in both of those systems, you were looking at point-to-point telegraphy. You weren't looking at complex, densely connected information environments. And we really live in a normative environment where we don't have agreement on what's fair game in terms of access to or destruction of cables in times of armed conflict. And that's something we should be worried about, because it doesn't just mean, for example, that screenagers like my son will lose access to YouTube and TikTok. It actually would be very disruptive also, not only to our diplomacy and defence capabilities, but to our trade. Right? The days in which ships turned up with several binders full of customs papers are long past. Ships are very frequently diverted mid-journey to new destinations. The paperwork that allows international logistics to work moves by submarine cables. Then in terms of climate change and maritime boundaries, I just sort of note, not only do we live in a world where many of our neighbours risk deterritorialisation, we've taken the step of endorsing the Pacific Island Forum statement on the permanence of their maritime boundaries, securing their rights to their exclusive economic zones and fishery and offshore resources potentially in perpetuity. But more than that, we've entered the Whale Union Treaty with Tuvalu, allowing for climate resettlement and full rights of residence for Tuvaluans in Australia. So in that sense, what we're doing in the maritime security space also becomes an element of our statecraft more generally. But I'll leave it there.
Thank you, Douglas. There's lots to unpack there, and hopefully we'll get to do that in the Q&A as well. Moving to the inimitable Dr Dominique Dalla-Pozza, a dear friend and colleague of the National Security College. Your chapter is on foreign interference and espionage, and I'm hard-pressed to think of anyone who knows this legislation better than you. What are the key issues in this area, and why do they matter?
Oh, thanks, Danielle. And it was a real pleasure to be asked to author this chapter, because it allowed me to further my interest in legislation and parliamentary process. So, Beck
Not dry.
Well, that's nice. But I was about to say, Beck and Danielle are put on this planet to look at what the courts do. My job, I think, is to focus on what Parliament does and the role that legislation as a source of law in its own right plays, even when the courts don't get the opportunity to interpret it and look at it for us. And so that leads me to look at the espionage legislation and the foreign influence transparency scheme legislation, which is what I do in the book. As my co-authors have said, please buy it. And think about it in terms of what do we want our legislation, our national security legislation, to look like. So my first point is that we need this legislation, a legislation to deal with these national security threats. I know that everyone in this room will have probably listened to and absorbed the Director General's annual threat assessment last week, where he did say, amongst many other things, that espionage and foreign interference are already at extreme levels and that ASIO anticipates they will only intensify. And the Director General also made the point that Australia has strong laws against espionage and foreign interference. So I agree we need legislation to address these threats, but we need to make sure that they are the appropriate laws, both in terms of what powers they give our agencies to be able to operationalise and respond to these threats, but we also need to make sure that they're appropriate for our liberal democratic context. So one of the key observations I did when I was working on the chapter, as Danielle asked me to, is that these laws are complex. Now that sounds obvious, but one of the reasons why the laws in relation to foreign interference, espionage and foreign influence are particularly complex is that we're talking about three distinct concepts, but which are actually interconnected. And so some of the complexity in the legislation comes from the connection between those three terms. But I will point out that the government has tried as clearly as they can, articulate that these things are different. But I think that that we need to be aware that although legislation can be complex, where there are areas of complexity, we want to make sure that the law is as knowable as it's possible to be. Looking at it on the page of the statute book before a court can ever get around to telling us what it means, just in case they never get the opportunity to do so. That leads me to the second observation that I made in the chapter, which is that one of the things that academics who are interested in this sort of thing watch for is where the laws are broad. And we need to be particularly cautious where laws are overly broad or perceived to be overly broad. Now, as long as the government can make a good case for why the laws expand to where they do, then that's an argument that should be heard. But when we're thinking about complexity, we also need to think about breadth. The final issue that particularly tickled my fancy when I was looking at especially how the Foreign Influence Transparency Scheme Act developed was to say that actually in the end this turned out to be a very interesting law reform story. So at the very end of my chapter, you'll see there's a postscript because after I'd finished writing it, the Parliamentary Joint Committee of Intelligence and Security handed down their review of that particular scheme. And I didn't have time to be able to, or the word space, to be able to integrate a full discussion of what the Parliamentary Joint Committee actually said. But one of the key recommendations they made was that the law required substantial amendment, that the Foreign Influence Transparency Scheme, although it had laudable aims, in its particular current version, it needed some very significant changes. In June of 2024, again after my chapter was complete, the current government responded to that and acknowledged that there were significant flaws of legislation and committed to a law reform project to try and improve them. And this tells us that the government recognises that the foreign influence aspect of the foreign interference espionage challenge is important, but that our legislative settings at the moment need adjustment. And so I'm looking forward to probably in the next sitting of Parliament, I have to say, not that I know when the election is going to be, but there will be a new round where we are thinking about what I've called in my head FITS 2.0. And I'm hopeful that we'll all have an opportunity to take that bill seriously and be able to engage in a conversation about it so that when it eventually does pass, it actually does the work that we need it to do in this important area.
Thank you so much. You can see why it was such a pleasure to work with these and all the other authors. Just to mention, we are recording a podcast tomorrow to unpack these details a little further with Rebecca and with Dr. Sangeeta Pillai, who was on the other end of an unnamed airline. Won't name the airline, let you guess. But thank you for getting here after all. And we're really looking forward to recording a podcast unpacking the citizenship issues tomorrow. So stay tuned for that. That will be on the NSC website in due course. So please join me in thanking the panellists for their time.